Hello everyone, and welcome to the Hackley and Robertson Conference Room series, where we talk about various immigration issues. I'm Kyle Hackley, the founding partner of Hackley and Robertson, and today with me, as always, is Ryan Kozabucki, who is a senior associate attorney of Hackley and Robertson. Today, what Ryan and I were chatting about and thought we'd share with you are what are the key elements when we are accepting a case, preparing the case, and filing a case with the USCIS, Citizenship and Immigration Services. That's the adjudicating agency when we're filing a case, whether it's an L or an O or whatever visa it might be. And we kind of came up with the three key elements, what we're really looking at in all three of those areas. Whether we'll accept the case must be true. If the facts of the case don't sound right, if the facts of the case lack credibility, then we're not going to take the case and we're going to advise the person likely not to try to present a case. So the facts must be true, and that's, I think, self-explanatory. The second is a case must be legally sound. And what we mean by that is that there's a statute found in the immigration laws. The statute are the laws. And the agency who administers the laws, the immigration laws, implements regulations that we must follow meticulously to make sure that the case is legally sound. Also, that what comes into play are the memorandums that the agency puts out, which tells us what their interpretation of the law is and their own regulation, and other things like the body of case law, the different tribunals that look at whether or not a case that's been denied, that's been appealed, is legally sufficient. And so we were talking about the other day a case where we thought that, thought for sure that the facts were true. Whether or not it was legally sufficient on its face, it certainly looked like all of the laws and regulations had been complied with. But then we kind of spotted something that maybe suggested the case wasn't quite ready for filing.
Yeah, this case, they're coming up a lot lately. It was an E2 case, and we noticed the case. Well, we advised that the case wasn't sufficient and not ready for filing because the investment was not substantial, because only a percentage of the $250,000 startup costs had been spent, and so at that point, the case was not ready to be presented before the consular officer to be adjudicated, because legally the requirement of a substantial investment just hadn't been met yet, hadn't been spent or committed sufficiently.
Yeah, I know what case you're talking about, and you're right. We've seen kind of too many of these lately, where let's say in the case, the example that you give, the investment is $250,000, and the person actually puts that $250,000, it does exist, into a bank account. And let's say they've spent $10,000 of that money toward the business. By the legal standard, it looks like the money has been invested because they have it, they put it into the business, but the law says that the investment, in order to be substantial, among other things.
Yeah, it sitting in the bank account didn't show that the investment monies were irrevocably committed to the success of the treaty enterprise.
Right, because it's it's just simply sitting in a bank account, and if the monies haven't been spent, then in fact
it looks more idle and speculative than an ongoing business.
So that case, will be ready for filing. They just need to spend the money, right? And then, well, we're good to go to put it together, and that kind of leads to the next issue. And something that I think might be too often overlooked, and that's the presentation of the case to the adjudicator. In some cases, it's going to the USCIS inside the U.S., or it may be going to a consular officer. We happen to be working on a case right now that we're getting ready to file. It's going directly to the USCIS, and without letting our viewers get a glimpse of who this case is about or what it's about. When this case is ready for filing, it's going to be two-pronged. Why? It's going to have the holes because it makes it easy for the adjudicator to put it in their file. More importantly, though, what it contains is a roadmap, right? I mean,
That's
isn't that what
exactly
we do? I don't know
right.
what other lawyers do, but what we do is create a roadmap so that.
Yeah, the cover letter being an important piece, so the adjudicator, and it really is an art to it. The case looks so easy to navigate through, but in fact, every piece of evidence has been carefully placed and it's been carefully described, so the adjudicator, by looking at the presentation of the case, has a sense of exactly what's in it, and every piece of evidence is narrated to describe
Right.
what does it go to show for the case. And so the roadmap letter for the adjudicator is certainly an important piece of the presentation.
Right, and part of that idea is just making the adjudicator's job easy. Instead of having a lot of different documents, we walk them through it. In fact, once before a case even leaves our office, and I don't know that many of our clients even know this, but the letters are drafted, they're reviewed, and they're re-reviewed. And again, without disclosing anything, you might be able to see all the red lines. We have looked at the best way to present the evidence. What is the best way to make sure the adjudicator sees it, knows that the facts that we're presenting are in fact goes to
Meeting
the
the
element
requirements of the law,
law.
meeting each element.
And because it's not just one requirement, in some cases there are many requirements and sub-requirements, and so it is worth taking 2-3 times looking through just our letter, and then organizing it with dividers. So when the examiner takes it apart and they can see the exhibit list, they're flipping through it, and if we can make their job easier, then it's worth the time. And honestly, we just care that much. Do you have any other
Which is true.
thoughts?
I don't have anything further to add at this time.
Other than how important it is that the facts be true, that the facts meet the requirements of the law, and with that, it's so important to lay out in the presentation that the facts do meet the law. So I hope that you have found that this somewhat interesting. Thank you for joining us. For more information on Hackley & Robertson, please visit our website at www.hackleyrobertson.com and follow us on Twitter at Immigration Pros. See you next time.
See you next time.